Welcome to Bankruptcy Unlocked, your legal path to relief.
Welcome to Bankruptcy Unlocked, your legal path to relief with attorney Andrew Griffin. If you're feeling overwhelmed by debt, you're not alone and you're not without options. Andrew breaks down the bankruptcy process in clear, compassionate terms, helping you understand your rights and take control of your financial future. Let's unlock the path to a fresh start together. I'm your host, John Clements, and today's episode is how bankruptcy affects your car, loans, and transportation. So first off, Andrew, hey, welcome back to the podcast.
Thank you. Nice to be back.
Absolutely. So let's just jump into some questions. What happens to your car in a Chapter 7 or Chapter 13 bankruptcy?
For many people, their car is one of their most significant assets, and in some cases, the most important form of transportation for work, family, and daily activities. If you're facing bankruptcy, it's important to understand how filing for Chapter 7 or Chapter 13 bankruptcy will impact your car, whether you're looking to keep it or are concerned about the possibility of losing it. Here's what you need to know about how bankruptcy affects your car in both Chapter 7 and Chapter 13. In Chapter 7 bankruptcy, the liquidation process means that the bankruptcy trustee may sell certain assets to pay off creditors. However, it doesn't automatically mean that they'll lose everything you own, including cars. The impact in your car depends on factors like the equity in the vehicle, the state exemptions, and whether the vehicle is financed. Exemptions in Chapter 7 bankruptcy, the exemption laws is that your state play a key role in whether you keep your car. Exemptions protect a certain amount of equity in your vehicle from being sold to pay creditors. If the value of your car is less than the exemption limit in your state, you can keep your car. For example, if your car is worth $10,000 and the exemption limit in your state is $5,000, you may lose your car, or the trustee may sell it and give you the exemption amount, if allowed. If the car is worth $5,000, it may be fully exempt and you would be able to keep the car. Now, secured debt. If you still owe money on the car, you are considered to have secured debt on the vehicle. If the car is exempt under state law, you can continue making payments on the car loan and keep the car. However, if you fall behind in your payments or do not reaffirm the debt in your bankruptcy case, the lender may repossess the vehicle. A reaffirmation agreement, if you want to keep your car and you're behind in your loan, you may be able to sign a reaffirmation agreement, which means you agreed to continue making the payments after the bankruptcy as if you were not discharged. This allows you to keep the car and catch up on missed payments. Now, you might lose your car in Chapter 7. If your car's equity exceeds your state's exemption limits, the bankruptcy trustee may decide to sell the car to pay creditors. However, this typically only happens if the value of the car is significantly enough to provide value to the creditors. If you're behind on car payments and can't work out an agreement with the lender may repossess the vehicle after the bankruptcy discharge, especially if the debt is not reaffirmed. Now, the impact in Chapter 13 is a little different. As you know, Chapter 13 bankruptcy is a reorganization process. It allows you to keep your property, including your car, while reorganizing your debt and making payments over 3 to 5 years. This option is generally better for those who want to keep their car but have fallen behind in payments and have a high amount of equity. In keeping your car in Chapter 13, you have to pay off the car loans through the plans. If you have a car loan and are behind on payments, Chapter 13 allows you to catch up on the missed payments by adding them to your repayment plan. Your plan will outline how much you need to pay over time, which can help you avoid repossession and keep the car. You can also cram down car loans in Chapter 13. In Chapter 13, if you owe more on a car than it's worth, for example, your car's value is less than the loan balance, you might be able to cram down the loan. This means that you can reduce the amount that you owe to the current value of the car, rather than the full amount of the loan. This could save you money in the long run, especially if your car is older and it has depreciated in value. The secured car loan in Chapter 13, if the car loan is secured, which is most likely it is, you'll need to continue paying the lender according to the terms of the Chapter 13 repayment plan. If the car is a necessity and you're not behind in the payments, it's typically allowed to remain in the bankruptcy estate and won't be liquidated. But when you might lose your car in Chapter 13? If you fail to make payments. If you're unable to make payments, if you're unable to stick to the terms of your Chapter 13 repayment plan, the lender may have the right to repossess the car. It's important to stay current on your repayment plan to avoid this. If your car is not essential, in some cases, if your car is not essential, it's not deemed to be necessary for your work or daily life, and its value is significantly high, the trustee may attempt to sell it to pay creditors. However, This is relatively rare, especially if the car is within exemption limits. How car loans are affected in both Chapter 7 and 13. Chapter 7, if you owe money on your car loan, Chapter 7 provides the opportunity to discharge the unsecured portion of the loan, or, if any, simply relieve you of the obligation if you surrender the vehicle or if it's repossessed, if you want to keep the car. If you want to keep the car, you need to continue making the payments and possibly reaffirm the debt with the lender. Chapter 13 allows you to reorganize your car loan debt. You can reduce the amount of the loan in the car if it's worth less than what you owe, and you can also catch up on overdue payments over the life plan of the repayment plan. These are the things that you should know when talking about keeping your car in Chapter 7 and Chapter 13.
And that's such an informative answer. There's so much good things to know about, how to keep your car, how to make car payments, how to reaffirm the car loan. Thank you for that. I do want to jump in to something. So in the last episode, we talked about what if you want to walk away from your house. I would ask you the same question. What are the risks of voluntarily surrendering your vehicle in case of a bankruptcy?
Voluntarily surrendering your vehicle can seem like a quick way to resolve financial strain, especially if you're unable to keep up with your car payments. However, this decision comes with a number of risks that could affect your finances and credit long term. Here's an overview of the potential risks involved in voluntarily surrendering your car. 1. The deficiency balance after surrender. One of the biggest risks of voluntarily surrendering your vehicle is that you could still owe the deficiency balance after the car is sold. The deficiency balance is the difference between what you owe on the car loan and the amount of the lender recoups when they sell a vehicle. For example, the loan balance is if you owe $15,000 on the car loan, and then the lender sells the car for $10,000, the deficiency balance would be $5,000. You would still owe $5,000 to the lender after the car is sold. So if you surrender the car, the lender would typically sell it at auction or another sales method. The sale price is often much lower than the car's market value and could still be on the hook for the remaining balance. Now, there's also impact on your credit score. Voluntarily surrendering your vehicle can significantly damage your credit score. A vehicle repossession, even if it's voluntarily, is reported to the credit bureaus as a negative mark. This will likely cause a drop in your credit score, and the impact can be long-lasting. Repossession in your credit report is a voluntary surrender is considered to be the same as a repossession. The lender will report it as such and will stay in your credit report for up to 7 years. It acts like a difficulty in cleaning your credit report. Having a repossession in your credit report can make it even harder to obtain future credit, especially for auto loans, personal loans, and even mortgages. Lenders may view you as a high-risk borrower because of the past failure to meet loan obligations. It also is ongoing collection efforts. Even after the car is surrendered, the lender may still attempt to collect the deficiency balance. If the lender is unable to recover the full amount through the sale, they may pursue collections, they may file a lawsuit, and this could result in court judgments, which might allow them to garnish your wages or place a lien on your property. Losing your transportation, while surrendering the car may help relieve your debt burden, it also means that you lose access to your vehicle. This could pose significant challenges, especially if you rely on the car for commuting to work, running errands, or transporting family members. Transporting issues. Without a vehicle, you may struggle to get to work or perform your everyday tasks, potentially affecting your ability to earn a living or meet other obligations. The other issue is potential for tax liability. If your car is sold for less than what you owe on it, which is often the case in voluntary surrenders, the lender may forgive the deficiency balance or report it as income to the IRS. If you cancel the debt, the lender cancels or forgives the deficiency balance, it might consider taxable income. This means you could owe taxes on the forgiven debt, which could result in a surprise tax bill. Now, the other issues are this. There's no guaranteed debt relief in bankruptcy. While bankruptcy can help debts related to car loans, voluntarily surrendering the vehicle does not necessarily free you from liability. In Chapter 7 bankruptcy, the deficiency balance may be discharged, but in Chapter 13 bankruptcy, it may still be needed to be paid through the prepayment plan. If you're thinking about filing for bankruptcy and voluntarily surrendering your car beforehand, you should understand the possible impact of your bankruptcy case. In Chapter 7, deficiency balance in your car loan may be discharged after surrendering the vehicle, but it's not automatic. You need to ensure the debt qualifies for discharge. But in Chapter 13, you may be able to include the deficiency balance in your repayment plan. However, you still may be responsible for paying off the remaining balance, depending on the specifics of your case.
Yeah, there's a lot more that goes into that than I thought. So I think the answer is call Andrew. I think that's before you turn your car in. Make sure you get this advice, because that's a lot of things to consider, and it's important. You don't want to lose your car and then still end up on the hook for debt or God forbid taxes. So thank you for that. And I do want to actually kind of bring those together and just ask you, what advice would you give someone who's trying to balance their transportation needs with a fresh financial start?
When a client is working to rebuild their financial life after bankruptcy or any other financial setback, balancing transportation needs with a fresh financial start is crucial. Reliable transportation is often necessary to maintain a job, manage daily responsibilities, and continue rebuilding credit. However, it's important to approach this decision carefully to avoid repeating past financial mistakes. Here's a guide of how clients could navigate transportation needs while maintaining a healthy financial path. 1. Assess your transportation needs versus wants. Before deciding on a vehicle, it's essential to determine your actual transportation needs. This helps you make decisions that align with your financial goals without overextending yourself. Look essential versus non-essential. Ask yourself, do you really need a car, or can you get by with the public transportation, ride sharing, or carpooling? Are you looking for a car to fulfill a practical need, commuting to work, grocery shopping, or are you leaning towards a status symbol or luxury vehicle? Set a realistic budget for your transportation. A clear budget is essential, and it should fit within your restructured financial plan. After bankruptcy, it's easy to feel the urge to rush into big purchases to get back on track. However, it's important to keep long-term goals in mind. Choose a reliable, affordable vehicle. After bankruptcy, it's important to prioritize reliability and affordability. Don't be swayed by flashy features or unnecessary luxuries. Used cars are just as good as new cars. Look at fuel efficiency. Avoid luxury brands. Be cautious of high-interest car loans. If you're planning to finance a vehicle after bankruptcy, you may be offered high interest rates because of your credit score. While it's natural to want to get a car quickly, don't get trapped into taking a loan with unfavorable terms. Shop around. Consider a cosigner. Look for subprime lenders and be cautious of them. Look for short-term loans. Also, you want to be careful about rebuilding your credit responsibly. While transportation is important, it's equally essential to keep focusing on rebuilding your credit after bankruptcy. Securing a car loan can be a good way to help improve your credit score, but only if you manage it wisely. Be mindful of buy here, pay here dealers. Some clients may consider buy here, pay here dealerships as a way to get financing for a car after bankruptcy. While these dealerships might approve you more easily, they often come with high interest rates, unfair terms, and hidden fees. It's important to read the fine print before agreeing to any deal, as these loans can be a trap for borrowers who are trying to get back on their feet. You got to explore alternates to traditional car ownership. If purchasing a car isn't the most financially viable option, there are alternative transportation methods to consider that might be affordable in the short terms. Make sure that you avoid rushing the decisions. In conclusion, balancing your transportation needs with a fresh financial start after bankruptcy can be tricky, but it's absolutely achievable. The key to being realistic about your financial needs, careful with your budget, and patient with your credit rebuilding process. By prioritizing reliability, staying within your means, and avoiding unnecessary financial risk, you can successfully navigate your transportation choices and keep moving forward toward a stronger financial future.
Thank you so much. Yeah, it's such a great framework, and to remind people that they have options. They're not just stuck with one option or the other, but there are things they can do. There are things they have control of. I love that. It gives that sense of hope and that they can take control of the situation. And I think that's a great place to end. So Andrew, thank you so much for being on the show today.
Again, thank you for having me.
Absolutely. And to our listeners, thank you for tuning in to Bankruptcy Unlocked, your legal path to relief, featuring Andrew Griffin. To connect with Andrew, visit andrewgriffinlawoffice.com and be sure to like, subscribe, and leave a review. And with that, have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.